Welcome to the 36th John S. Bainbridge Moot Court Competition. Just a word before we begin. Much has been said in the last couple of weeks about judicial temperament. I want to say something about the temperament of a lawyer and moot court, just for a moment. I was just told by one of our associate deans who participated here as a student in moot court. I won't say who, but she told me that in oral argument, she cited a case from the Ninth Circuit, and one of the judges on the panel shot back at her very sharply. You know that we don't regard the Ninth Circuit as controlling authority in this court. Words that would have struck terror into many experienced litigators. And this precocious and wonderful student and lawyer responded, well, perhaps today will be different, Your Honor, which I think shows the kind of equanimity and temperament that lawyers require in order to be persuasive advocates for their clients. I'm delighted that we give our students the opportunity to be grilled, to be excoriated, to be everything but humiliated by a panel of really congenial and wonderful lawyers that we recruit each year to keep them on their toes, to test them, to make sure that they can think on their feet and respond to tough questions. It's a great exercise. It really does test the most important of lawyering skills, and I look forward very much to the results. So welcome once again, and now I want to introduce to you Jillian. Jillian Oliff will introduce the competitors and will present the case. Jillian?
Good afternoon. On behalf of Toro Law Center Moot Court Board of Advocates, I would like to extend a warm welcome to the 36th Annual John S. Bainbridge Moot Court Competition. Today's competition is a accumulation of the hard work and dedication of our two finalists, Amanda Schaefer for the petitioner and Farrah Faraci for the respondent. The issue in this case is whether, for purposes of establishing a 1983 civil rights claim, an inmate at a correctional facility can legally consent to sexual conduct with a guard, or if such conduct is per se non-consensual. In this case, there's a circuit split on whether a prisoner can consent to a relationship with a correctional officer. This question implicates a constitutional concern, namely, prisoners have an Eighth Amendment right to remain free from cruel and unusual punishment, including sexual abuse by guards. If prisoners cannot legally consent, then any sexual relationship between a prisoner and a guard necessarily violates that right. Thank you.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for this court is now sitting. God save the United States and this honorable court.
Good afternoon. Before we start, I'd just like to introduce the panel of judges. I am Lewis Silverman. I'm a traffic court judge in Suffolk County. I also am a retired professor from Toro Law School and ran this program for 20 years with Professor Melniker, so I know something about what the competitors are going through right now. To my far right is Justin Block. He's president of the Suffolk County Bar Association, and I've known Justin since he was about knee-high to a grasshopper. To my immediate right is Joseph Dell from Dell Dean. To my immediate left is Elena Karabatos, the president of the Nassau County Bar Association, and on the far left, Evan Krinick, the managing partner of Rivkin Radler. We'll have more to say later. At this point, I will call the case of Maya Dimas versus James Benson and Jorge Marquez. Is appellant ready to proceed?
Yes, Your Honor.
And is respondent ready to proceed?
Yes, Your Honor.
All right, may we have the names of counsel, please. Appellant, would you give us your name?
Amanda Schaefer for the appellant.
Spell your last name, please.
S-C-H-A-E-F-E-R.
Farrah Faraci for respondents.
Okay. And are you requesting rebuttal time?
Yes, Your Honor. I'll be requesting 2 minutes.
All right. All right, you ready?
Ready.
You may proceed.
Your Honors, may it please the Court, my name is Amanda Schaefer, and I represent the appellant in this action, Ms. Maya Dimas. Your Honors, I would like to request 2 minutes of rebuttal time.
Granted.
Would the Court like a brief recitation of the facts?
No, we know the facts.
Your Honors, this case is about 2 correctional officers who engaged in intercourse with an inmate who was subject to their control and custody and confined to the 4 walls of a prison. The appellant requests this Court to reverse summary judgment on the grounds that an inmate cannot consent as a matter of law to intercourse with a correctional officer. In support of her request, the appellant presents 3 arguments. 1, the power disparity between an inmate and a guard renders the inmate incapable of giving voluntary consent to intercourse with the guard. 2, the new New York penal law demonstrates that inmate-guard relationships are per se non-consensual as according to the contemporary standards of decency, and thus they also violate the 8th Amendment. 3, in order to deter these relationships, in order to further the interests of public policy, it is necessary to deter these relationships so that the security of the prison system can be preserved and victims of sexual abuse can be provided with restitution for the injuries they have suffered. As to my first point, Your Honors, the power disparity between the inmate and the guard renders the inmate incapable of voluntarily consenting to
In all
intercourse.
circumstances, or can there ever be an exception?
No, Your Honor. In all circumstances, the guard maintains a position of authority over the inmate that extends to every detail of the inmate's life. And this was recognized by the District Court of Delaware in Carrigan v. Davis. In that case, the court held that an inmate cannot consent as a matter of law for purposes of a Section 1983 claim because the officer controls the inmate's life while she is in the prison. For example, Your Honors, the inmate cannot control when she goes to the bathroom, when she eats, when she goes to sleep. These are all determined by the correctional officer. The correctional officer also has the power to write disciplinary reports against the inmate and to provide recommendations to the Department of Probation. And for these reasons, the court found that inmates cannot legally consent.
Why isn't the Woods decision, which creates a presumption, adequate to meet the problems that you see?
Your Honor, the Wood test is inadequate because it fails to recognize that the coercion is inherent in the inmate-guard relationship. Your Honor, an officer can rebut the Wood presumption by getting up on the stand and testifying, Your Honor, the inmate did not say no to me engaging in intercourse with her. That's enough on...
What about a situation where the inmate actually initiates the contact?
Your Honor, in this case, which leads me to my third point, Your Honor, it's necessary to deter guards from engaging in this conduct. Because of the power disparity and because of the authority that inmates hold over the inmate, it is necessary to deter guards from engaging in the relationship. The guard is the only party with the power to say no, Your Honors.
But in this case, isn't it your client who wrote the second set of notes to the first corrections officer apologizing for, in essence, cheating on him?
Your Honor, the record reflects on page 9 that, yes, my client did write notes to the officer, and in her notes, she told Officer Benson that she was scared, she was alone, and she missed her family and friends. In full awareness of these facts, Officer Benson chose to arrange his work shifts, as the record will reflect on page 4, and on June 21st, 2013, Officer Benson led my client into a broom closet and engaged in intercourse with her. And by abusing his authority, he took advantage of my client, who was confined to the four walls of a prison cell.
And
But wasn't the modified Wood standard as adopted by this court below, wouldn't that kind of balance protecting the inmates as well as the guards from being sued?
No, Your Honor, because the guard maintains such power and control over the inmate, an inmate may not feel comfortable to say no to this person from whom she takes orders, who has the power to write disciplinary reports against her.
You think there's no circumstance under which an inmate could abuse this, if there's factual consent, and abuse this in order to gain leverage in a lawsuit against the prison?
No, Your Honor, because the inmate will not even get to the point where she files a lawsuit if the guard doesn't engage in this conduct in the first instance, which leads me to my third point. It is necessary in the name of public policy to deter the guards from engaging in this conduct, and also to provide inmates with restitution for the physical and/or psychological trauma that they suffer.
But, Counselor, we're talking about a constitutional violation here, and that's a very strong threshold to achieve. And I'm concerned that if we have an absolute standard, then we're making a constitutional standard too lenient and too easy, and that there may be factual circumstances which shouldn't come within that purview. Can you address my comment?
Your Honor, like anybody who brings a civil claim, an inmate must prove her case by a preponderance of the evidence. And the best defense for an officer is not to engage in this conduct in the first instance. These are officers who are entrusted with maintaining the security and the order, the law and order within the prison environment.
What civil rights were violated here? Didn't she consent to this on a factual basis?
Your Honor, my client is asserting that her Eighth Amendment right to be free from cruel and unusual punishment was violated in this case. As a matter of law, she could not consent, and this is for two reasons. One, when the guard engaged in intercourse with somebody who was subject to his custody and control, his conduct served no legitimate penological purpose. And the Supreme Court held in Rhodes v. Chapman that where an officer's conduct has no such penological purpose, it constitutes cruel and unusual punishment.
Well, Counselor,
You mentioned the penal law earlier, and I know you haven't had a chance to address that yet, but perhaps you can tell me what the relevance of the penal law is to a constitutional claim.
Yes, Your Honor. The Supreme Court in Gregg v. Georgia held that where conduct violates the contemporary standards of decency, it constitutes cruel and unusual punishment under the Eighth Amendment. And in particular, the court directs us to look to the acts of state legislatures in order to find evidence of these contemporary standards. Therefore, the new New York penal law evidences that the people of the state of New York find that these relationships are per se non-consensual.
and yet, in a state with a similar statute, the state of New York, so a couple of federal courts have held in similar circumstances that there is not a constitutional claim.
Your Honor, two courts in the state of New York have recognized the applicability of the penal law in a Section 1983 lawsuit. In Fisher v. Gord, the court recognized that the criminal law may be imputed into a civil rights lawsuit. In addition, the Northern District of New York in Cache v. County of Erie also found that where conduct violates the criminal law, the inmate may also state a constitutional claim. The court in McGregor v. Jarvis did not. However, in that case, we had an instance where the officer was engaging in quid pro quo with the inmate, and he was using his authority to smuggle marijuana into the prison for the inmate. And this presents a very severe security risk, which needs to be addressed by establishing a per se bar against this conduct.
Counselor, let's just, for the moment, arguendo, assume that the prisoner is not capable of giving consent. However, if consent is established as a factual issue, would that remove the case from an Eighth Amendment claim?
Your Honor, could you please repeat your question?
Let's assume that consent is not possible based on the state statute, but on a factual basis, there appears to be consent. Would that then remove the claim from an Eighth Amendment issue?
No, Your Honor. And by holding that an inmate cannot consent as a matter of law, it is regardless what the inmate might do factually, because the officer is always going to be in a position of power and authority over the inmate. And the court in Kerrigan v. Davis recognized this, Your Honor. Corrections officers maintain control over the inmate that extends to every detail of that inmate's life. And inmates need to be protected from abuse of authority by these officers, which lends me, Your Honor, to my first point, that the court in Kerrigan v. Davis did recognize that that inmates are unable to consent as a matter of law because they are vulnerable and they are the ones who are confined to a prison.
But don't you think that the fact that they left it out of the constitutional claim, they addressed it in the criminal claim, right, in the statute, they left it out of the civil statute, don't you think that evidence is a legislative intent to allow it to be considered and to allow consent to be pled?
No, Your Honor. Rather, appellant believes that the existence of the criminal law constitutes evidence of contemporary standards of society, such that it also constitutes cruel and unusual punishment under the Eighth Amendment when an officer engages in intercourse with an inmate who is subject to his control in custody. And in order to further...
Do you think there's anything improper with having the plaintiff having to swear in a statement that is non-consensual on a factual basis? Do you think there's anything improper with that, for having to plead that?
Your Honor, as a matter of law, an inmate should not be able to consent to intercourse with a corrections officer. It is necessary to protect inmates from being abused by those who are in authority over them and from those who are trusted to protect them from harm.
What about if they get some sort of benefit from it?
Your Honor, the officer is the party who has the power to abstain from engaging in quid pro quo conduct with inmates. The officer is the one who is free to go home at night. The officer is the one who can say, no, I'm not going to engage in this conduct and jeopardize the security of the prison system.
But the officer also is the one who can give them more time on the phone or give them extra commissary privileges. And if an inmate is willing to engage in sexual acts in order to obtain some sort of benefit, doesn't that imply consent?
Your Honor, for that very reason, there needs to be a per se bar established so that officers will understand that this is unacceptable conduct. The onus needs to be placed upon the officer because they are the party that maintains control within the prison system.
Is there of any other relationship in where there's a per se rule that consent cannot be obtained no matter the circumstances, or is it limited to the prison environment?
Your Honor, in this case, we are addressing the very narrow issue of an inmate who has been subjected to sexual abuse by a prison officer.
What if, assume we ruled in your favor, assume there's a per se rule. What constitutional rights have been violated for any other inmate who fell in love with a corrections employee and is now denied during their incarceration a physical relationship with that employee, assuming they're even at whatever prison they're in, they're allowed to have conjugal visits, but now because that person they've fallen in love with in that setting is an employee, they're barred from having a relationship because of our ruling. So in protecting your client, we could create a constitutional issue for the next inmate.
Your Honor, in this instance, the public policy goals that favor the maintenance of the security of the prison system override any of the interests that you have just described.
Counsel, what remedy are you seeking today?
Your Honor, we are asking the court to reverse the lower court's grant of summary judgment.
And then what?
And then, Your Honor, it would be remanded back to the lower court.
For what purpose?
In order for the lower court to apply this new constitutional standard, Your Honor, to my client's claim. Thank you, Your Honors.
Counsel will give you time to conclude.
Thank you, Your Honors. So for the foregoing reasons, the appellant respectfully requests this court to reverse summary judgment and remand it to the lower court. Thank you.
Thank you. You did reserve time for rebuttal. Whenever you're ready, Counselor.
I'm ready. Good afternoon, Your Honors. May it please the court, my name is Farrah Faraci, counsel for the respondents, James Benson and Jorge Marquez. This case is about lawful sexual conduct that occurred between two correctional officers and an inmate at a state correctional facility where the inmate used these relationships to her advantage is now claiming an Eighth Amendment violation. Therefore, respondents respectfully ask this court to affirm the lower court's decision and hold that consensual conduct between two adults is not unconstitutional as a matter of law for the following three reasons. One, courts have recognized in the past that inmates and correction officers can legally engage in sexual conduct that is not unconstitutional. Two, removing consent as a defense would have dire repercussions. And three, this court should apply the Wood standard. In regards to respondents' first point, there are several circuits that have held that sexual conduct between inmates and correction officers is consensual. In Hall v. Bevan, the Sixth Circuit held that an inmate's Eighth Amendment rights were not violated when the inmate engaged in sexual conduct with the correction officer.
Well, at this point, Counselor, the case is at the stage of a summary judgment motion. There's been no testimony. We only have competing affidavits. Shouldn't we perhaps remand it for a hearing on the question of consent?
Your Honor, Ms. Demas has not used the opportunity to hear this on the basis of consent. Going back to the circuits that have agreed in correctional officers' favors, and Fridas v. Olt, which was the Eighth Circuit, in that instance, the guard did initiate the relationship. However, the inmate's actions were enough to show consent on his part. In that case, the inmate and the guard would go to secluded areas of the prison. They would kiss, make out. However, the inmate in turn would send very flirtatious and sexually explicit notes to the guard. And the court in Fridas held that sexual interactions, no matter how inappropriate they may seem, is still constitutional as a matter of law.
But don't you feel the inherent disparity in their positions, an inmate versus a corrections officer or guard or employee, it is just so weighty that there's really an inability for an inmate to ever really consent to that relationship? I mean, if you look at the notes that were written, it seems there's a relationship where the inmate's trying to gain some type of favor from the relationship, and that alone should be a reason that these acts should never occur.
Your Honor, in this particular case, Ms. Demas, she had power. She used it upon her own initiative to initiate these relationships on several instances. She had the power to bring this claim to a court of law. She was not influenced by any other guard or inmate within the correctional facility. And as indicated by the record, she issued several notes and letters to both respondents.
But didn't he take advantage? I mean, she said she was lonely and she was sad, she missed her family. Didn't he just take advantage of that and then use it for his own benefit?
Your Honor, as a matter of law, it is still constitutional for an inmate and guard to engage in sexual conduct.
But there needs to be a knowing, voluntary waiver, right, and consent?
Your Honor, in this instance, Ms. Demas initiated these relationships on several instances.
You commented on power. Can you explain what you meant by her power, that she had the power? What power did she have?
Your Honor, she had the power to initiate these relationships. 2 days when she entered the facility, she was already beginning a friendship with Respondent Benson, and which eventually turned into a sexual relationship on her own
Don't
will.
you think that, though, don't you think that also there's a potential that it could appear that she was doing it and it wasn't in fact consensual, and that she felt scared or she was doing it for other reasons?
Your Honor, there is no coercive factors indicated by the record. As seen by the notes, indicated on page 10, in a note that she addressed to James Benson, she stated, "Last night was amazing. I hope you get assigned to guard me more often, thinking of you."
Well, but before we get...
Excuse me, go ahead. No, I was just going to ask about the guards. How do you protect the inmates, given what you're saying? You're saying that the inmate has the ability to go and to do this, and you think it's not incumbent on the correction officers to simply say no? Aren't they trained? Aren't they the ones holding the position of power here?
Your Honor, this is why the Wood standard should be applicable, because...
Do you mean the Wood standard or the one modified by the court below?
The Wood standard, Your Honor, because...
Oh, and not by the court, as modified by the court below?
Well, yes, on a case-by-case basis using the Wood standard, yes, Your Honor.
Okay.
Because it is still bringing the inmates' rights First, the inmates still have an opportunity to bring their claim to a court of law with a presumption that there is no consent on an inmate's part.
Well, it could be fairly read, Counselor, the first couple of emails, that they were just establishing a friendship, that the plaintiff was scared and this guard had been friendly to her, and she was just establishing, you've been nice to me, thank you, and then the relationship, who took it further? Did she push the sexual conduct, or did he see that she was susceptible and scared and that he could get something out of her, and did he push it? And if he's the one who pushed it, isn't that all the more reason for a very firm line?
Your Honor, respondents did not give Ms. Demas any unfair treatment or anything that could be used to her advantage in the system, while she did look for it. As in one instance, she was having a problem with an inmate, so she addressed a note to Respondent Benson, indicated on the record, page 10, stating, can you maybe get her moved to a different cell block? So she was clearly looking for favors from these guards. When Ms. Demas was in solitary confinement, Respondent Marquez was assigned to her. While she was in her cell, she invited him to come in and, as quoted, for a little fun.
But chronologically,
what's your response to the claim that the penal law, which makes this relationship illegal, establishes a constitutional violation as well?
Your Honor, the penal law is based on a state level. This is a federal level here where several circuits have held that sexual conduct between an inmate and a guard is consensual.
But why shouldn't it apply? Why shouldn't the New York penal law apply? Why shouldn't that be the standard?
Your Honor, there are moral holdings in favor of allowing for consensual conduct to take place here. And going back to the Wood standard, Respondent's third point, it maintains a fair balance system in this case. Yes, the inmates have an opportunity to bring her claim to a court of law by showing the presumption that there was no consent. However, the guard should have the opportunity to defend themselves and show that there is no coercive factors present. As clearly seen in this case, she was not coerced into these sexual conduct.
So you could have a situation, as I understand, where the guard winds up being convicted of a crime under the state statute, and yet the inmate has no constitutional redress, even though the guard has been convicted.
Your Honor, in this instance, she initiated all these relationships on her own. It was consensual as a matter of law. For them, conduct between two adults is consensual.
How is it consensual as a matter of law?
Your Honor, she started these relationships with several notes and letters indicated by the evidence. She asked them to do favors for her, looking for a favorable treatment. However, when she realized she could not use these relationships to her advantage, she decided to bring an Eighth Amendment claim.
But that goes against your argument. If she's starting these relationships and sleeping with the two guards so that she can gain some type of favor, that's coercion. That she's in essence being coerced because of the position she's been in. She knows if she does this for a guard, the guard's going to do something favorable for her. That makes her more of a victim.
And the reverse is that if she doesn't do this for the guards, she may not get treated equally with the other inmates.
Or worse.
Aren't you concerned that if we open the door up to constitutional violations under facts like this, inmates will have an incentive to set up guards and go and try to create constitutional claims where they otherwise wouldn't exist?
Your Honor, this is why it's important to have the Wood standard in this case. In order to maintain a fair balance, it is important to deter inmates from trying to manipulate the system, to look for either early parole, unwarranted credit for good behavior. They can use these claims as a threat against the guards so they can receive the type of treatment that they are receiving.
Do you acknowledge that in a typical prison situation, the guards hold the power?
Your Honor, yes, guards have power. However, the inmates, in this case, Ms. Demas had power as well. She had the power to start these relationships. The respondents did not start these or coerce her into these sexual relationships. She did it all on her own initiative. She took it upon herself. She was not influenced by anyone throughout this whole process. A prime example of how an inmate can manipulate the system is in Fisher v. Gord. In that case, the inmate, Amy Fisher, her mother, and their lawyer devised a plan in which they would have one of the guards call them up, and they recorded this guard to use as leverage against him, so to see if he could say anything incriminating or sexually explicit against the inmate, Amy Fisher, all because she wanted to be moved to a facility that was closer to her home.
Counselor, does it matter who initiates the conduct, whether it was initiated by the guard or the prisoner? Let's say it's a clear case that the guard initiated the conduct. Would that still foreclose an Eighth Amendment claim by the inmate?
Well, Your Honor, going back to Fridays v. Old, the guard initiated a relationship in that case, and it was still held that it was consensual because the inmate's actions in perpetrating it were enough to show that there was consent among his part. Which is,
Would you agree that?
I'm sorry, I was going to say, wouldn't a per se rule, though, protect the guards as well? You just say, this is not possible. This is not possible. Everybody knows. Don't you, by your standard, isn't that opening up the guards to potential more risks, saying maybe we can do it, maybe we can't? Isn't it better just to have a clear rule?
Your Honor, yes, it's always good to have clarity. However, it isn't. In this instance, it is important to apply the Wood standard as like a case-by-case basis here.
Didn't a court in Fisher recognize that an inmate used to be able to consent?
Your Honor, yes, Your Honor. However, this is why the Wood standard is so important, to maintain a fair balance between the two parties. The guards should have the opportunity to defend themselves in such an instance here.
If the defendant is not liable in a constitutional sense, as you would argue, would it be appropriate nonetheless to be terminated from his employment for this type of conduct?
Your Honor, it would be important to have this argued in a court of law to decide, using the Wood standard, to have the inmate show that there was no consent among her part, and then have the guards show that there was no coercive factors.
But he could be convicted in a state court for his acts.
Yes,
So
Your
if he
Honor,
could be convicted in a state court, he should hold his position as a corrections officer?
Your Honor, this is on a federal level here.
Well, the claim's on a federal level.
Yes, Your Honor.
Right. The 1983 action is a federal action.
Yes, Your Honor.
Amendment, right? What I'm saying is he could still be convicted, as my colleague said, on a state level.
Yes, Your Honor. However,
In fact, I believe it's a felony.
It is important to maintain a fair balance to avoid opening the floodgates to numerous unwarranted claims going into the system.
The chronology of the notes, she's asking for favors, right? Laundry, mopping, being moved. And then, on June 22nd, she thanks him for a wonderful night, which I would assume they had intercourse. So doesn't it seem that she's in a position where she wants something favorable to herself, and she's willing to then have sex with a corrections officer to try to get that? So why not have a bright line rule where they just can't have a relationship, where they just cannot have one?
Your Honor, it is still, as a matter of law, constitutional for two adults to engage in consensual conduct.
Counselor, are you arguing that an unwanted sexual conduct committed by an inmate, committed by an officer, can never be an Eighth Amendment violation, even if it serves no penological purpose? Is that your argument, that they can never be an Eighth Amendment violation?
No, Your Honor. In this particular case, though, there was consent among Ms. Deems's part. She initiated these relationships.
Well, Counselor, if we apply the Wood test, or let's go back to the original Wood test, not as modified by the trial court, wouldn't that compel us to remand the case for an evidentiary hearing at the trial level?
Yes, Your Honor, if the opportunity is granted. However, we're still putting Ms. Deems's interests first here by allowing her with the presumption that she had no consent on her part. Respondent's position is that it is fair for them to be able to show that there is no coercive factors present here. When she was in solitary confinement and Respondent Benson found out about her relationship with Respondent Marquez, she issued a note to Respondent Benson, indicated on page 10 of the record, stating, "I didn't know why I did it. I just thought maybe I could get out quicker if he was on my side," clearly showing she was just using them to her advantage to gain unfair benefits.
Isn't
Would
solitary...
would it be different if she didn't initiate it? Because you place a lot of emphasis on her choice to initiate it. If she consented and she wanted it, but she didn't initiate it, same facts except he started the conversation, Would your opinion be different?
Your Honor,
Counsel,
here's
you
my
may answer the
time.
question and then conclude.
Thank you. Your Honor, in reference to your question, if she didn't consent to it, the Wood standard would still protect her because it gives her the first rebuttal, the first presumption that there was no consent. And if there's no consent, then they show that there was coercive factors present, which is what the Wood standard is all about, maintaining a fair balance between the two parties. Therefore, given that Ms. Demas did initiate these relationships on several occasions to use to her advantage, respondents respectfully ask this court to affirm the lower court's decision. Thank you.
Thank you. Ms. Schaefer, you requested 2 minutes rebuttal?
Yes, Your Honor.
Whenever you're ready.
Your Honors, my opponent has repeatedly stated before this court that it is necessary to employ the Wood test in order to, quote, strike a fair balance. However, there's nothing fair about the relationship between an inmate and a correctional officer. The correctional officer maintains a degree of control over the inmate such that he tells her when to go to bed, when to go to the bathroom, when to take a shower.
Why isn't it sufficient protection for the inmate if the officer is subject to penal liability under the state law, and I would believe disciplinary action as an employee? Why do you need the Eighth Amendment to provide that protection for the inmate? Isn't they sufficiently protected by other remedies?
Your Honor, an officer may lose his job. He may also be thrown in prison. However, that still leaves the victim without the restitution she requires in order to be compensated for the injuries she has suffered.
You don't think there could be use of this?
Your Honor,
Claim?
Your Honor, an inmate will not even get to the point where she can bring a suit if it's clear to officers that they cannot engage in this conduct. And that's why a per se rule is necessary in order to tell those who are in authority that this conduct is not only inappropriate, it's not only illegal under the penal code, but you also will be held liable for violating this inmate's constitutional rights. And this lends appellant to her third point, that in the name of public policy, in order to afford inmates the restitution for the physical and or psychological trauma that they suffer by being abused by those whom they trust to protect them and to maintain law and order, it is necessary to hold that as a matter of law, an inmate cannot consent.
Is it fair to visit liability on the state for the actions of somebody who may go rogue?
Your Honor, could you please repeat the question?
Sure. Is it fair to visit liability on the state for a guard who may have gone rogue, who goes outside his responsibilities and does this even though he knows or she knows that he or she shouldn't?
You may
Your
answer
Honor,
the
may I
question.
finish your question? Your Honor, we have not gotten to the point where damages or indemnification or qualified immunity has been an issue or where it needs to be assessed. However, by creating a per se rule, the deterrence value would not only extend to officers, it would also extend to their superiors and provide them with a great incentive to properly train their officers to abstain from this despicable conduct. Thank you, Your Honor.
Thank you, counsel.
Thank you.
The court will be in recess to deliberate.
Can everybody please remain in their seats? We have about 5 to 7 or 8 minutes left. I'm sure the judges will return with their judgment in just a few minutes. In the meantime, congratulations to our competitors. I hope that every one of you does as great a job in your appellate advocacy arguments in the spring in your legal process class as these two individuals did here today. We are all very, very proud of both of you. And now I want to reintroduce Jillian Oliff, the editor-in-chief, to make a couple of comments. And again, as soon as the judges return, we will pass the microphone over to them. Thank you all for coming. Please remain until the event ends. Thank you.
I would like to thank you all for attending the 36th would like to thank you all for attending the 36th Annual John S. Bainbridge Moot Court Competition. On behalf of the board, it's my pleasure to welcome you. While today's competition is a accumulation of the hard work and dedication of our two finalists, the success of the competition would not have been possible without the support of the executive board. These individuals make themselves available throughout the summer, and our senior and junior members each contributed countless hours aiding our finalists. I thank each and every one of them for all their hard work. Furthermore, I would like to express our gratitude to Dean Harry Ballin, the faculty, and the administration. We would also especially thank Dean Myra Berman, Dean Linda Barrowley, Professor Melniker, and Professor Schwager for their countless hours in assisting us in preparing for today. I ask that you join me in giving them a loud round of applause. We are proud to announce that this year's recipient for the George C. Pratt Award is Professor Melniker. You have dedicated countless hours. Enough. Thank you. For joining us, and we hope you have enjoyed watching the arguments presented by our two finalists.
Oyez, oyez, oyez.
I'll bring this robe. I don't know where it tonight. That create an impact? It will level it.
Thank you. Court is back in session. What we're going to do now is I'm going to give a little, on behalf of all my colleagues at their request, I'm going to give a little critique of each one of you, and then each judge is going to just make a couple of comments about appellate argument, merits of the case, whatever they want to say, just to sort of introduce themselves, and then we'll announce who is the winner. We thought you both did wonderfully. First semester, second year, you know, you just did fine, and you can both breathe, you can relax now. It's over until your next competition. Ms. Schaefer, your roadmap was a tiny bit too long, and you spoke a little too quickly. Both of you were using one hand to speak while you had the other one on the lectern, but that was something you both did. You got to watch that. You cited some case law. You didn't make enough reference to the record. Frankly, when you go out in competition, they want to hear references to the record. And you were a little strident. Not every statement deserves a level 10 pitch. Okay, I think you softened up at the end, and your rebuttal was a little softer. But you sort of gave the same volume for everything. So you need to get a little more inflection. Your rebuttal was pretty good until Judge Block threw you a question that sort of stumped. Two little pet peeves of mine from having done this. Your conclusion started for the foregoing reasons. The word foregoing belongs in a brief. It does not belong in oral conversation. And you said my opponent. It should be my adversary. Just it's more professional when you got up on the rebuttal. Ms. Faraci, you had a briefer roadmap, and I think it got us there a little faster. You did make references to the record. You had some problem answering the questions, and there were two particular issues. What I always have taught students is have 3, 4, up to 6 points in 18-point font in front of you. When you finish answering a question, go immediately to one of the points. A couple of times we were sitting here waiting for you to then go somewhere, and you were waiting for us to ask a question. You need to take us where you want to. You did have some difficulty with some of the questions, I think, and you showed it on your face a couple of times. Your answers were fine, but sometimes you struggled, it's just something, it's nervousness rather than anything else. You need to get over it. But we think you both did wonderfully, and I think you're going to be a great credit to the school when you go out in competitions. I've told Dean Berman, as I'm available to help practice moot the teams at any time, especially if it's family law, Professor Schwager. So I look forward to your representing our school in these competitions. At this point, I am going to turn the floor over to my fellow justices so that they can give comments on whatever they wish to give comments on, and then we'll announce the winner. Justice Block.
Amanda, that's what came through. When you started out, and you relaxed a little bit at the end, but when you're talking to the judges, when you're trying a case, when you're in an appellate argument, relax. Because you came off as Judge Professor Silverman said, kind of strident and aggressive. Your body language, you were leaning in, you're very intense. And that can make it a little off-putting for the judges. So relax. You know your case better than the judges do. Okay, so when you're talking, let more of your personality come through as well, so that the judges can get to know you and like you a little bit. Overall, I thought your presentation was really good. You were clearly well-versed in your arguments, you understood where you were going, and that worked great. And I didn't mean to throw you for a loop with that last question, but one of my notes was, why wasn't the state named as a defendant? I wasn't going to ask you that question, but it was one of the questions I had. But I thought you did very well. Farrah, I thought you did great too. You were bombarded with a lot of things, and there were a couple of times when it seemed like you needed to get your feet back under you, and you took a little time to do that. So just be ready that there's more questions coming. Okay?
Justice Dell.
First, let me thank you both for allowing me to come in and judge, because I'm not really a judge. We have one, but I'm not one. I try cases and argue cases for a living, and have done it for 27 years. So to have a first semester, second year students, right, come in here and do this, it's amazing. You both did a great job. I think, and I differ a little bit from my colleagues, you have to be who you are when you argue a case. So if you're someone who's a little zealous, use your hands a little, like I do, then you have to be yourself. But you have to be aware of how it's being received. So you have to pay attention to that. Like Judge Silverman said, if you have a good point and you've made it, and you don't want to pause. You want to go right into something else that's good for your client. And I think in your situation on the facts, you had all these notes that helped you, and I would have hammered away on the notes, because you can't deny them, right? It's the evidence that you have. So if the evidence is on your side, hammer it home. I was just really impressed by the two of you. I know a lot of lawyers I argue against at my old age, at 52, who can't do what you guys did today. So thank you, and just keep going.
Judge Karabatos.
Thank you. First of all, you're both really brave. I was remembering when I was at your level, there's no way I would have done this. But anyway, so congratulations. What I want to say is I'm a divorce lawyer by training, so I try cases, I go to the appellate division, I do arguments all the time. What I've learned, and the only thing, and this is for everybody, I think that one of the things about advocacy is being a good storyteller. I like what you say, you have to be yourself and paint a picture. And there's two parts, and when you want to tell a really good story, one of the most important parts of it is visualize it, articulate it, and when you're being asked questions, you have to actively listen and really try to understand. And when you understand where those questions are coming from, but you have your picture, you're able to then take those questions and then go back and shape it back into your story. And that's what advocacy is about. And you have to just take a deep breath. And so what I would just say, and this is in general, you can get locked in to your argument. But you have to then take those 3 deep breaths and really say, wait, those questions are being asked, but here's my story. But oh yeah, this is how the story goes. So that's what I would say to you, because it's really about storytelling. And I will say, and I do believe one side of this case in some ways is more compassionate than the other. Most cases are like that. So when you find yourself on the less compassionate side, and certainly divorces, that happens, find it. Find what it is that makes that. So that's what I would say. You both did a great job.
Justice Krinick.
Well, I'm not going to repeat what some of my colleagues have said. I think you both did really a terrific job. I was very impressed by both of you. Did you have fun? Because it's supposed to be fun. Really, appellate advocacy, it's a lot of fun, especially when you're done. So you should really be smiling now. It really is a lot of fun. And I think what impressed me the most, and I would ask you to remember this, is the passion you both brought to the argument today. Because when you get into private practice, you may not come up with a constitutional issue. And frankly, you may not feel passionate about your client's point of view. But your job is to act like you believe in your case. I think you both did a very, very good job today of convincing us whether you do or you don't, because I have a feeling you could have switched sides and both done equally excellent jobs on the other side of the argument. But I think you convinced all of us that you believed in your case. And that really is rule number 1 of appellate advocacy. The court has to believe that you're right in order to convince us that you're right. So I commend you on that. And I would just urge you as you go forward in your moot court competitions or in private practice to try to remember the passion you had here today for this competition and bring it to bear every time you get a chance to represent a client. Really a terrific job. Thank you.
I would just like to say to the audience, because I know the first-year class is here, that remember, 2 of you are going to be sitting up here a year from now, and I hope you've paid attention. These advocates were excellent. They're a credit to their professors, they're a credit to the school, and they're going to be a credit to the Moot Court program when they go out into competition. And I hope that each and every one of you has been able to see the amount of preparation that's necessary, but the results that can be achieved when you work very hard at it. Now, unfortunately, one of you is going to win and one of you is going to be the runner-up. It is a competition, and it is my pleasure to announce that it was very close, but the winner is Ms. Schaefer. And court is adjourned.